Good
Okay.
afternoon to everyone. I hope everybody's well today and looking forward to an amazing event. Uh, Donald Berkelhammer is my favorite person to have this conversation with. I often refer her to my clients. She's phenomenal. And this is a great opportunity, ladies, and we're going to get started because Donna always has so much to share with us. And will we have a Q&A afterwards, Donna?
I will try my best, but I've got about one slide per minute. So
Okay.
We'll see. I completely updated this seminar because I first wrote it in, I think, 2015.
Okay.
And just to give you a sense of how much things have changed, a lot of the icons I had in that first presentation, those services aren't even with us anymore on social media. So put your comments in the chat. I will try to get to them, Phyllis. If you see we have comments, let me know.
Sure.
The other thing I want to tell you at the beginning is after this presentation, Phyllis and Nathaniel have a copy of my slides. So everything I have, you can have. So don't feel like you have to copy it all down because some of them I'm going to blow through, and don't worry, you will get all of that. Just listen. And I'm a lawyer. I work with small businesses. I help you start up, get a good foundation, grow, and then buy or sell. So this is something I think we have a lot of questions about. I think people start using social media for marketing, and sometimes you don't really think about what you're doing and how you're doing it and what it means. So hopefully you'll think a little and have some skills and some knowledge from this presentation. And I'm going to turn off my camera because I'm at home, and sometimes if my neighbors are heavy on what they're doing at lunchtime, the video quality gets really bad, and I don't want that.
Okay.
Oh, can I share my screen, Phyllis?
Sure. I need to change the permission?
Uh-huh.
Okay.
But I'm going to get started talking while you're doing that. So what is social media? Let's start with that. Turn my camera on while I'm talking. I can give you really technical, interactive technologies that facilitate blah, blah, blah. I can tell you blogs, microblogs, instant messaging, podcasts. But really what social media is generating business through internet traffic. All right, here we go. Can y'all see that?
Yes.
Okay. So generating business through internet traffic. Here are some of the kinds of things that count as social media. Some of them you may use in your business. Some of them you may not. It might not be appropriate to your business. So, that's all marketing. What platform works for me? Where can I reach my customers? Like for me, I would never be on Pinterest because it's a really visual medium and nobody wants to see piles of law documents and law books. So that's not a good medium for a lawyer. Social media law, it's a lot of the same old laws that would apply to traditional marketing. But we have new technologies, new platforms. It's really easy to get in trouble because of that right-click button where you can copy and paste. And you have to stop and think. So that's my old rotary telephone that you may never seen before. And it's now like in the palm of your hand anywhere you go. So stop, think. We're going to go over the laws and places where every section I'm going to give you tips on what to do. What is social media law? It's criminal and civil. We're not going into criminal. That's things like stealing, like hacking into computers and stealing stuff, or getting permission to go into a database for one purpose and doing it somewhere else. harassment, threats, that kind of thing. We're not talking about criminal law because you are all respectable business owners and you're gonna not do that. So civil laws, which is when people sue each other, state level, federal level, how to protect what you've posted, and how to not post inappropriate things from other people, privacy rights. And I have one slide at the end on employee rights, but we may not get there, and that's fine. That's not a big deal. All right, so what are we going to discuss specifically? Advertising laws, intellectual property laws, torts, which is where we're talking about civil wrongs, where people can sue you, and employment laws if we have time. All right, first thing I want you to know, the First Amendment does not say what you think it says. It says Congress shall make no law that interferes with your right of free speech, which means they can't read the newspaper in advance and tell the newspaper what to publish. The government can't stop you from making political speech. But you can say things in the public marketplace that give you consequences. Celebrities do this all the time. You know, the Dixie Chicks had a concert in Russia and criticized President Bush for the war. And all the country music fans said, that's not right. We don't want you on the radio anymore. That's not a free speech problem, a First Amendment problem. That's a marketplace problem. What you need to know is that political speech has a lot of protection, but commercial speech doesn't have full unfettered protection. There are restrictions that are legal to put on free speech, on commercial speech. And the Federal Trade Commission is the federal agency that's in charge of monitoring false advertising, endorsements, and privacy is what they regulate. So the false advertising guidelines on the federal level are basically your ad must be truthful, not misleading. You know, if you have a survey, 75% of dentists say use this gum, or 53% of consumers prefer whatever. Have evidence to back it up. They are going to scrutinize, in particular, the industries I have listed there. So if you're in any of those industries, you should do a deeper dive on what the advertising regulations are. I'm going to give you materials at the end afterward that link to a lot of these places, but the FTC, Federal Trade Commission, has a lot of very user-friendly guidelines for businesses in particular. So what can the FTC do if you have a misleading ad? They can file an action in district court, in federal district court, because this is a federal law that orders you to stop whatever it is you're doing. They can seize assets, they can get compensation for victims. So what does it look like? This is a complaint that was filed against Lions Not Sheep Apparel. What Lions Not Sheep did was advertise their Made in America, actually pretty aggressively. And it turns out they were importing apparel from China and doing some minor finishing work in the US and cutting out the Made in China label and putting a Made in the USA label on there. So the owner of this company is named on this suit, Sean Whalen. They're seeking, made them stop immediately. They're, I forget, like a crazy amount of money they're seeking in damages. And this guy is not allowed to have an internet business for a long time, basically. Here's another one. This is the company Intuit that owns TurboTax. and they advertise like crazy. You can file your federal tax return for free, except that 75% of people that file tax returns don't qualify for their free services. So they got this complaint. They had to stop advertising free. They had to notify all their customers, and they're under monitoring from the FTC. On the materials at the end that you'll get, I put an FTC action about, they call it a testimonial. So when we do endorsements, you can see how the FTC, it's one that came across my desk yesterday and it was too late to put it in the program, but I put the whole press release so you can see how they worked. FTC also monitors endorsements. What you see here is a screenshot of Kendall Jenner on Instagram, so hyped to announce my Good Music family as the first headliners for Fire Festival. What you don't see is she had a discount code for you to get tickets to Fire Festival, which ended up being a disaster. It was a festival on an island, marketed as very very exclusive, very luxurious, and they just didn't have the infrastructure, and people were in FEMA tents, and there wasn't food, there wasn't sanitation. The whole thing was considered fraudulent. Kendall Jenner implies that her brother-in-law is going to play music there. What she didn't say was she was paid money, like $250,000 to promote this festival. And when the whole festival dissolved and there were lawsuits like crazy, the festival was put into bankruptcy because it owed a lot of money. And the bankruptcy trustee actually sued Kendall Jenner for $250,000 for violating the endorsements. So when you have people endorse your goods, the FTC requires that you disclose a connection so that the customer can understand, oh, Kendall Jenner didn't necessarily think this was a great thing on her own. She got paid to do this. So if you are blogging about products and the manufacturer gave it to you, disclose that. If you have affiliated marketing sites where, click here and I'll get a few cents from you, buying this product from my site. If you were paid for your opinion, if you're an employee, any connection you have to what you're endorsing, disclose it. And reasonable disclosure. So if you're doing videos, maybe have writing on, the bottom of the first screen when you're doing the introduction, have a screen at the end that says, I received blah, blah, blah for free to try out. Just what's reasonable. Make sure people can see it. Again, the whole point is not to mislead the public, and so that when you're giving your testimonial or endorsement about something, they understand you have a connection and they can factor that into how much they credit your review. Okay, the violating endorsements is on the sponsor. So if you have people, influencers, reviewing your goods and services, have an agreement with them, make sure they know what they have to do and monitor what they do, be clear about compliance, yank them if you need to, and you as the sponsor, be truthful, don't mislead your public. Be real careful with your influencers and what you expect of them. Questions so far? Okay. Yeah, I know they're the chicks now, but I'm old school. All right, so privacy. There are not that much federal privacy laws. If you are marketing to children, there's a law you have to comply with. Otherwise, you need to have somewhere on your website, this is not marketed to children under 13 and they shouldn't use my website or buy anything from me. Financial data, health data, consumer data, if those are in your goods or services, just make sure you're aware you have heightened and federal privacy laws that govern what you do with your information you collect from people on your website. This does not apply to most of the businesses I work with, but those are the ones that are available on the federal level. The main thing to know is if your website has a privacy policy, whatever you say you're doing with the information you collect, make sure you actually do it. I try to not collect a lot of data, so I don't have to worry about securing it and being hacked and people stealing stuff. So just think about it. You know, if you're using e-commerce, have a third-party credit card processor that collects all the information and you don't have it, that kind of thing. There is now cyber liability insurance. And you can, you know, if that's something that's of interest to you, you can talk to your commercial insurance agent about that. Another federal law is CAN spam, which protects consumers from misleading email campaigns. What you need to know is this applies even business to business email, even though it's a consumer protection email statute. So basically what you need to know is if you're doing email campaigns, you need to be able, and I have all of this on your materials, you need people to be able to opt out. So I just use MailChimp. There's lots of creative constant contact. There's all kinds of email providers that make it really easy for people to be able to unsubscribe. But you know, don't mislead people on your email campaigns. And you'll be okay with CAN spam. But I have a lot more information about that in the materials. Going to move on to intellectual property, which is a lot of the stuff you're going to be posting in social media. It's content, trade secret, copyright, trademark. Trade secret is something that gives your business value from not being known by the general public and not being readily determinable by other people. So if you can look at something and figure out how they did it, it's not really a trade secret. Copyright protects photos, artwork, works of literature, dance, copyright, sculpture. It's works of authorship. And trademark is your brand. It's a word, phrase, symbol, or design that identifies your company as the source of goods or services. I honestly never thought I'd be talking about trade secrets with social media, because secret and social media is kind of an oxymoron to me. Where it comes into play in social media is generally customer lists. This is a case. Phone Dog Noah was a employee who was on MySpace and created a huge number of customers for his company, and he did reviews of I think telecommunication and technology. And he developed a huge social media following, and when he left the employee of the company, he just took that account with him. And the company sued him for stealing their trade secrets because they said those customers that followed his account, I think it was Twitter, were their property. And he says, how could that be a trade secret? If you go on Twitter, you can look at everybody who follows me and you can get them for yourself. And that case ended up settling out of court. But what it proved is that the Twitter list had value, and it might have been the property of the company and not the property of the employee. There's another case where there was a woman who was the CEO of a company, completely not computer literate. The company's marketing department created a LinkedIn profile for her, managed it for her. And then when she left, they just changed the name on the account and kept everything and all the followers the same. And she sued them for that case. It was misappropriation of her name. As it was all her stuff that it was done under, and violation of trade secret. Again, settled out of court. But the point I want you to know about all this social media, if you have employees that are running your social media accounts, make sure it's clear that the account belongs to the company, and make sure you as the employer have the account login and password information, because you'd rather not be in the situation of a disgruntled employee left and took all your customer names with them. So again, try to be preventative rather than reactive. All right, copyright. All the pictures you want to post, content, photographs. If there's music playing in the back of your video, that's where copyright comes in. Copyrights attach at fixation in a tangible medium. So you save something in the cache on your computer, there's a copyright on that. You take a picture, you make a drawing. Copyright goes to the author, usually. Copyrights is an exclusive bundle of rights, and it's in the Constitution. It is designed so that an author has a period of time where they can exclusively commercialize their product, and then it'll go into the public domain so we can all base stuff off of it. Right now, it's set for an individual, it's 70 years from the life of the author plus 70 years. So things that are in the public domain, I want to say like 1912 or something like that. It's crazy how long it is that you can't use stuff. So if you are a business and you have an employee that creates something for you, you own it because they're your employee. But if you're a business and you hire an outside person to create your logo or your website or art for your website or brochure, technically they own that work because they created it and they're not your employee. So you need to make sure you have a work for hire agreement that says when I pay you the final payment for creating this for me, you transfer ownership to my company. It's a hiccup in the law that's very confusing to people. So I want to make sure when you hire people out, at the end of the day, they assign that work to you. Copyright infringement is violating any of those works. You copied it, you copied part of it, you sold it, you distributed it. And there's a lawsuit right now with Taylor Swift being accused of copyright infringement for one of her songs. And her defense was, I never heard that song before. I couldn't have copied it. Because you can see here, it's circumstantial evidence. How similar are they? And did the infringer have access? And it's hard to know what your liability would be if you're using parts of people's work. The remedies are your actual damages. If you infringe someone's trademark, how much money did they lose because of you? What are their lost profits? And there's also, if they're a registered trademark, there are what we call statutory damages. So you can see if they can prove you had access and you copied their stuff willfully and not unintentionally, it could be as much as $150,000 per work. So it's really important to make sure you're not infringing someone else's trademark.
Excuse me, Donna, we have a question in the chat.
Yes.
I use Beaver for logo and for website content. Am I covered?
It depends what your contract says. It's all contract law. And I'm not familiar with those services, so I haven't looked at those.
Okay.
You should look and see what the terms of service are.
Okay. Thank
All
you.
right. So you are allowed to use other people's materials a little bit for certain products, certain types of works. Criticism, commentary, news reporting, teacher scholarship, research, or parody. What you need to know is this is a really complicated area of law, and it is a defense to copyright infringement. So what it means, if you're arguing fair use, I had the right to use this because I'm a nonprofit, or I had the right to use this because this was political commentary. You've been accused of infringement and you're trying to defend yourself. Here are the criteria that a court is going to balance. It's a balancing test. There is no specific number of words, lines, or notes that may be safely taken without permission. This is a quote from a Supreme Court case. Very complicated. A lot of misinformation surrounding fair use. Used to be, oh, it's on the internet, I can use it because they put it out there. If I only use a little bit, I can copy it. If I don't charge for it, I can use it. I just need to give the author credit. All of these maybe, but it's not a get out of jail free card. So what do you do to get information on your site? And it's hard because social media is social. You put stuff on there because you want a lot of people to see it. And you have all these share, like, retweet, pin buttons. And what if somebody put something up there that they didn't have the right to put up, and then you send it out too? You might have some liability. When you are getting information, content for your social media, first official answer is get permission from people to use their stuff. And I realize, you know, they have that like button there. They have that share button there. If they didn't intend for me to share it, why is it there? It is murky. This is new technology, and the copyright law was in the Constitution, you know, 200 plus years ago. And the law is slowly trying to deal with internet computer stuff, and it's not a good fit. First takeaway, you know, think about where you're putting your share buttons. What do you do if somebody has taken your stuff? One thing you can do is Digital Millennium Copyright Act takedown notice. If you have a website, you can put a takedown notice in your terms and conditions. It's a safe harbor. So if you have something on your site that's copyrighted to somebody else, registered, they can, if you have this takedown notice, there's kind of a safe harbor for you. And there's a procedure to notify someone that they have copyrighted information that needs to come down. That can help you if you are unintentionally violating someone's copy. But you can also use that against other people who have your proprietary information on their website. So that's a safe harbor, Digital Millennium Copyright Act. I have information on that, how to use it in both cases in the materials I'm going to give you. This is a picture that a Haitian photographer took in 2010 when there were those bad earthquakes in Haiti. And he tweeted it on a service to share it, to get the word out how bad it was. He was one of the few people on the ground. Another photographer said, oh, it's on Twitter, it's free to use, retweeted it, took credit for it, and ended up selling the rights to this picture to several worldwide media companies and getting paid for the licensing. And the original photographer sued him. And the point is, just because it's on Twitter doesn't mean you can use it. That's how it happens. That's a really extreme example. So what do? Create your own content. pay for content either by hiring someone to create it for you or going on a site that lets you use content for certain uses. Pay attention to what you're allowed to use it for. I had a client that went on, I forget what site, it was a freelancer site, and had someone create a logo for her product and had labels made. And then we realized really late in the game that her labels, she was limited to a certain number of labels under the license, under that service. So I don't remember whether it was like, you can print 200 labels or 1,000 labels, but that's all. So pay attention to the terms of use. I've had places where I go that is a communal licensing site, something like Creative Commons, where I found a picture I want to use for one of these seminars. And I go to the terms of use. It says you can use it, but you have to give the author credit. There was not a name of an author anywhere. I ended up using his Flickr handle because that's all I could find. These are really good resources, but you need to pay attention to the fine print of what you're allowed to use them for and how you can use them. When you're online, there's linking and framing. So if you have a link to other people's information on your site, which we often do, here's resources, here's, the history of such and such, here's government sites that have information you need. Just make sure what you link to isn't like, here's the stolen copy of the new Tom Cruise movie script, because you might have some liability for linking to suspicious content. And framing is where you, and I don't know technically how you do this, but you take other people's website and you kind of put it into your website, but your ads and your content is around it, and it looks like you created it, but it's theirs. That doesn't happen so much anymore. That used to be a real big problem. Be careful of background music and songs if you have video content, because those are somebody's copyright and you don't have the right to publicly perform them or have them playing in your background. You see that a lot on YouTube, where like physical trainers will be showing you something and the gym music's booming in the background and they didn't have the rights to play that song in that context. Again, watch out for work made for hire. Get those agreements. Make sure you have the rights to content, and put a takedown provision in your website, because that's a safe harbor that'll help people. Do we have comments, Phyllis?
We have a comment from Colleen Smith. That's how you give attribution through the Flickr name, and the CC license you can use with the photo.
I'm sorry, how or?
Hold on, it's a lot more. I have another one. This was from Colleen Smith, so I guess we'll speak to her for a second. Ms. Smith?
Hi, yes, you were talking about Creative Commons, the website, and giving attribution to the artist or the photographer. You said you couldn't find the name. You're supposed to use the Flickr name that the photographer posts the photos with, in addition to the type of Creative Commons license that you can use that photo with. So it's supposed to be at Flickr's name by CC and then 2.0, whatever the license that they said that it's available for.
Yeah, I ended up using their handle because technology is not my thing, and I was trying really hard. I was just like, and it didn't say handle, it said name. So I guess in my head, those are two different things, but thank you. Okay, we are going to move on to trademark. Oh, I'm sorry, copyright trolls. So there are companies that buy up rights to lots of photographs to represent the photographers, and then they have web crawlers that find that you put this picture on your website and you're not licensed, and they send you these horribly scary, really mean letters that ask for thousands and thousands of dollars in licenses and damages. It's a cottage industry. Sometimes if you just respond back, they go away because they only want the people they can scare. Sometimes they don't. But the way you approach them is first make sure you actually did have that picture on your website. Does whoever contacted you actually represent that photographer? Is the copyright registered with the Copyright Office? Because if it's not, they can't sue you. What's their standard licensing fee? You should only pay that. Do you have fair use? This is a good time to get a lawyer. I personally don't handle those. I have people I know who do, but those are scary situations. They happen a lot. And sometimes you're really stuck. And it's unfortunate. And it's a real big pitfall for small businesses. So just double, triple, quadruple check what photographs you're using, what artwork you're using, and that you have the right to it.
I have a comment.
Okay.
As a business, would I be able to share the name of bigger companies we have worked for? Or would I need to get the company's permission? Example, being we did work for ExxonMobil. Could we share that information on our website or social media account without reaching out to those businesses?
The first thing I would do is look in your contract with them, because there may be a provision in there that governs how you can refer to the work you did. And often big companies will say, you can't without their permission. Mm-hmm. We're going to get into that right now. So that's a great segue into trademarks, because, you'll be using their name and their logo probably on your website.
Okay, one more question.
Yeah.
Do we need to copyright our logo?
Cannot copyright a logo. You can register it as a trademark. And if you have the money, yes, I 100% think you should. You can do it on the state level or the federal level. If you want to know more about how to do that, just contact me after, because that's beyond the scope of this.
Okay.
All right. So trademark, pretty much anything that helps the consumer find your company. Trademarks, like you register your trademark, you protect it. It's a valuable asset of your company. But it's also consumer protection, so that, if I want a really high quality something, I can go buy, the brand name. Or if I just want something that works, I can go to the dollar store and, get a jug of detergent for $1.25 in an orange bottle, but it's not Tide. How do you use trademarks on your website? Or your social media? You can advertise honestly. I fix boards. I'm a Microsoft certified technician. We sell Levi's jeans, all those kinds of things. And this is where it comes in. I've worked for so-and-so and so-and-so and so-and-so. Be truthful. Don't be misleading. Where you can get permission, check your contracts. I think the worst case, if you honestly said, I worked for ExxonMobil, and you put the logo on there, that's not really trademark infringement, but it might violate your contract. I think you just get a letter saying, please take that off. I don't think you have a lot of liability for that, provided you're honest. You can also, it's sad for business owners, but you can, excuse my language, have suck sites. They're not as popular as they used to be because there's so many online review places. But that is commercial speech that's protected by the First Amendment. Something that often comes up with internet searches is keyword advertising, where you buy, if people search certain things, you get ads that you put there based on their search. So the first time I did this speech, it was cold, and I searched fleece jackets. And if you can see those first three ads, or those first three results are ads. And the government didn't think people were smart enough to know sponsored results meant advertisements. And so there's a rule at the FTC that keyword advertising has to be designated as an ad. So that's why you see that little yellow ad on Google. And then where that green arrow is on fleece jackets, that's the searches, the organic results. So I believe the sites will automatically put that on there for you. There's a lot of case law about, well, if I have keyword advertising for my competitors' names and, then comes up to my ad, sometimes you're not allowed to do that. Most of the SEO companies you're working with will know these rules. And there used to be like you'd put your competitors' names in white print on a white background in your website to try to steal people that are searching for them, and it'll go to your website. You're not allowed to do that. So if you're using trademarks, you need to use them honestly and not mislead people, just like everything else we've talked about. When you're naming your brand or your advertising, don't use words or logos that are similar to another person's brand. That's what trademark infringement is, something that's substantially similar and likely to cause confusion. Be careful on social media with other people's products. Sometimes, you might have a video, you're standing in your kitchen shooting something, you have brand name products behind you. Are you unofficially endorsing them? That kind of thing. Again, like we talked about, if you have comparative ads, you can say, Bounty is more absorbent than, than Brawny. Have claims to back that up, but you can say, Bounty is the most absorbent paper towel. Like that's kind of fluffing. So be truthful. Don't be misleading about your comparisons. And you want to police your own mark. So if you have trademarks, you have brands, goods and services under a brand name, have at least a Google search so that you can see if other people are using them. You can monitor the conversation, and you can tell if people are infringing you. Questions? Okay. We are going to switch to civil wrongs, torts. In social media, this would be violation of privacy and defamation. Privacy law is state by state. I have listed here the 4 different kinds of right to privacy, and North Carolina only recognizes the 2 that are in blue. So kind of generic right to privacy is so that, you can't put cameras in the changing room at work, and your neighbor can't get a telephoto lens and, take pictures of you in your kitchen. That's not really social media usually. Where it is effective on businesses is the right of publicity, which means you have the right to control your name or likeness. So this is an ad when Michael Jordan was nominated and installed in the Basketball Hall of Fame. And Sports Illustrated had a special commemorative issue and solicited advertising. So this is Jewel Osco. They are a drugstore and grocery store in Chicago. And this was supposed to be just kind of image advertising. And I am sorry, I meant to print out the words in big language and I forgot. But what you need to know about this, it was like, congratulations, Michael Jordan, from your neighborhood grocery store, which was their slogan. And Michael Jordan sued them for violating his right to publicity and unfair trade practices. And he has trademarks in 23, and it violated his trademark, and assumed he was somehow endorsing Jewel Osco. It ended up settling out of court, but the issue was that this was not image advertising. It wasn't just Jewel Osco celebrates Michael Jordan. It primarily has the 23 shoes, and it has their logo really big, and it had their advertising slogan embedded in that text. And I'm really sorry I didn't print it out so I could read it to you. So this was a problematic ad. Violated his right to control his own image and how people use it. Here's another one. This is actress Katherine Hagel, and she was in her neighborhood shopping at the local drugstore, and a paparazzi got her picture, put it on Twitter, hey, I saw her, here's where she's shopping. And the drugstore, Dwayne Reed, this is their tweet, can't resist shopping at NYC's favorite drugstore. Again, that is their slogan, your favorite drugstore. And she again sued them, saying, I just shopped there. I'm not endorsing you. I don't want people to go there because I went there. You misappropriated my likeness. I have the right to control it. This is invasion of my privacy. And that one settled out of court. They made a contribution to an animal rights organization on her behalf. I think if, they had taken this picture and the bag was a little more turned and you could have just seen the logo, and they retweeted it without putting their corporate tagline on there, it probably would have been okay. But they made it into commercial speech. And when it's commercial speech, it has more regulation than just regular speech. And this probably did violate her right to privacy. Here's another one that I thought was a crazy case. That trench coat in Casablanca is made by a company named Burberry. And on their Facebook page, they had a timeline of their different styles and fashions and how they were used, and kind of a history of their company and the fashion, how it evolved. And they just said 1942, Humphrey Bogart wore a Burberry trench coat in Casablanca. They talked to the person who took that picture and got a license to use it for editorial purposes. And then his estate sued Burberry for stealing his likeness. So he's been dead a long time, and states like California and Tennessee because of Elvis, have really broad right to privacy statutes that protect dead celebrities and not just live people. So this one settled out of court, but they, so they used this picture to say, here's how our company has evolved, and they got in trouble for right of publicity. All right, my next slide, defamation, and at the end, I'll talk to you how to avoid all this. They're together. Defamation is a false, unprivileged statement of fact. So anything you say in court is privileged. You can defame somebody as much as you want in the courthouse, and the person can't do anything about it. If you're on the floor of Congress and you're a congressman or a senator, you cannot be sued for defamation. But regular people in their regular days make statements all the time, and most of them are unprivileged. There's no shielding from you saying something false. Harmful to someone's reputation, published, which means somebody else heard it for a spoken thing, with negligence or malice, like you should have known better, you just saying mean things because you don't like them. That's defamation, and that is an injury to your reputation. If you make a false statement about somebody's business or professional character, that is what we call libel per se. And you don't have to prove what the damages are. Damages is how much you pay if you lose a lawsuit. So if you're defaming somebody's business, they're going to get money. What is the defense to defamation? It was true. It was an opinion, or it was a fair comment on a matter of public interest. So where this comes into play is blogs, bulletin boards, chat rooms, comments. There's actually case law from, I don't know, the 90s, the early 2000s, where bulletin boards were state of the art, where the court ruled that bulletin board and chat room comments are just on their face considered opinion and hyperbole, and whatever people say in there isn't defamation. So if you're talking bad about, I had this bad experience with a dentist, or that restaurant has roaches, or, it's the worst hamburger I ever had. That's the worst massage I ever had. Massage therapist smells. That's not really actionable. If it's harassing, threatening, bullying, that could be actionable. That's different. That's not defamation. So it was helpful at the time for people that were commenting that this isn't defamation, but it's really hard on businesses. So Congress passed the Communications Decency Act. And this is a safe harbor for your website if you have user comments on there. So no provider, that's you as the blogger, whatever, wherever your comments are, your website. If you put that on the internet, you're the provider. Or user is a publisher. So the publishers of defamation are the ones that get into trouble. The newspaper that printed the article that, whatever, that made the false statement about someone, or the speaker. So just because you have a social media account that people can comment on, and they say something false and negative about somebody, you don't have liability for that, just for having the blog. So this is a really good safe harbor for you. Also know that civil wrongs are based in the state where they occur. If you have a website, people could buy your products or services from anywhere in the world. And if something goes wrong and they want to sue you, if they're in the furthest reach of Alaska in a small village and they ordered your product and it harmed them there, they might want to sue you in Alaska, and you would have to hire somebody in Alaska to represent you and trek all the way out there. So make sure you have terms and conditions on your website that include the jurisdiction and venue. Jurisdiction is what law applies. Venue is what place it's going to occur in your hometown, so that anybody that's damaged by your goods or services will have to come to you. So privacy defamation, same things we've been talking about all along. Be truthful, be respectful, get consent of anybody whose photograph is on your website in any of your materials. A lot of businesses, when you sign up for their services, there's a photo release. Website terms and conditions. You want to be able to kick people off your website if they violate your community standards. That's something I put some resources there for where you can get those for free. I can do those for you. I know a lot of people that come through the Institute, there's cash flow and startup issues. So I did give you some low cost resources that are good. Monitor and moderate comments. You can very respectfully say, hey, I am so sorry there was a fly on your plate. That is not our standard of operation, and please give us a chance to give you a gift certificate and come back. You can be polite and still put your side of the story on there. What you don't want to do is get into an argument on social media with a unhappy, unreasonable person, because that just makes you look bad. But you can absolutely say, hey, I am so sorry. I'll have my manager reach out to you and let's resolve this. You don't want to just let it lie, but you don't want to get into a debate online. Be careful, though, that Section 230 Safe Harbor, if you are editing people's comments and moderating them and you put in a mistake, you are now the publisher. So either let them go or remove them completely. But if you put in a mistake in somebody else's comment, you could be in trouble. Also, if you have a lot of advertising online, you can get cyber liability insurance and different kinds of advertising insurance. May not be relevant, just want to mention that it's available. And as far as employment law and social media policy, if you have employees and if you have large social media presences, you may have an employee that does your policy, or you may have employees that are on Facebook and they're friends with each other and they start bitching and moaning about how horrible their job is. The National Labor Relations Board governs unions, but it also governs general workplace. And one of the things they're very concerned with is a social media policy that would illegally and unfairly prohibit what they call protected concerted actions. So you are allowed to form a union. You are allowed to be disgruntled at work and talk to your coworkers about working conditions. A lot of social media policies are way too broad in trying to protect the company brand and put restrictions on employees that are against that law. So if you need a social media policy for your company, that's a good place to spend some money with an attorney. That is all I'm going to say about employment law and social media. And I am willing to take questions now.
My name is Donna Flowers. I'm the owner of OM Goodness Pimento Cheese based in Eastern North Carolina. Is there any way that you could restate what you were talking about if someone purchased a product like in Alaska, you use that example? Could you restate that if you don't mind?
Yeah, so if you don't have any kind of a contract with your customers and they are injured by your product, they are injured where they are. And if they needed to sue you, they're going to go where they are to file a lawsuit against you. Unless, your website has a term and condition that says by using this website and buying our products through our site, you agree that any lawsuit between us is going to be in, the Eastern District of North Carolina.
Okay. Thank you so much. I hope I never have that challenge, but
I know,
you
me
just
too.
never know. Thank you.
Sure.
I have a question. Can I ask?
Sure.
I hired a company to do like a logo, and they advertised what they had on the logo. And months later, they tell me that that was no longer available as they strung me along and kept telling me they were checking on it. They finally made a logo, and I wasn't pleased with it because it was the one that I didn't okay. And I also asked for separate things, and they have unlimited editing. Long story short, they did not produce what I asked. And I just said, at this point, let's separate and just give me back the money I paid. And I just want to go somewhere else. And they said, sorry, we can't do that. That's our policy. So how do you handle that if they're like in Canada or somewhere else? And what do you do at that point? What recourse do I have?
You would be looking at an action, a lawsuit for breach of contract. It might be worth hiring an attorney to send a letter, but it's going to be really difficult to get anything back. I don't know, maybe if you put it on a credit card, you could dispute it with your credit card company.
Mm-hmm.
That's going to be hard.
Okay, would they have to come here because I file it here?
They're going to talk to me. Just email me after. It's really complicated. I could walk you through it, but it's not really social media.
Okay, thank you so much.
Okay, we're still here for your questions. Now's the time.
This is Donna Flowers again. I just want to state that I've been through some of these types of classes before, and this one by far super exceeds every single one of them. It really dove in to some things that I've never heard about before. So thank you so very much.
I'm so glad. That makes me so happy.
Anyone else before we go?
I tell you what, Phyllis, anybody who has more questions, you can email me and we can talk. I'm happy to give you more specific information to your specific situation.
Oh, Donna, this is great. This is from Michelle Medley. Thank you for this information. Right when I think I know it all, I learn more. Thank you. Have a great day. Thank you, Michelle. Ladies, this has been amazing. I didn't see that we had any men, but so I say thank you, ladies. I enjoyed as well as I learned a lot, but that's always with Donna. Always. Unfortunately, this is her last webinar with us for this year. But hopefully she'll be back next year. And that's not far away, guys. But
we'll talk later, Phyllis.
Yeah. But thank you guys for joining us. And as she said, you can contact Donna on her website. Donna, can you put that in the chat?
Yes.
Because I don't have it. Thank you, Donna.
And I have a blog on my website, which has a lot of information too. So you can sign up to get that every week.
Okay, we have another question. Can we take this one, Donna?
Sure.
Okay. If I take a picture of a person wearing the product I sell, wearing the product that I sell, they just purchased, with her verbal consent to publish on my social media, does she have the rights over the picture?
No, but I wouldn't do it with just verbal because then you can't prove she consented.
Right.
And if she's upset later, you can't prove it. But no, you took the picture, so you're the author. It's your trademark and she consented for her likeness. So no, but it's murky when you don't have writing to back you up.
So it's best, guys, from what Donna is saying, is to get things like this in writing always. Okay, well, we're going to close it down for today. Donna, I want to thank you and all of the attendees. I hope you all did what I did, enjoyed and learned, and we'll speak with you at another time. And I'm standing in for Nathaniel Spurger. Bye for now.